The Health Insurance Portability and Accountability Act, or HIPAA for short, covers a wide range of issues including the assurance and portability of health insurance coverage for patients, as well as providing legislation to maintain reasonable and appropriate safeguards for protection of patients' health information. The HIPAA law is not new. The initial legislation was passed in 1996, which mandated a privacy compliance date of April 14, 2003. A core component of the HIPAA law is the protection, use, and disclosure of PHI, or protected health information. The law defines PHI as individually identifiable health information transmitted or maintained in any form or medium, including orally or written. Additionally, this law covers any PHI transmitted or maintained electronically, which would include voicemail and email communications, for example. Essentially, any manner in which this information may be shared with others is covered under this statute. As the law states, PHI includes individually identifiable health information, which will include any of the items listed on this slide. These include names, names of employers, telephone numbers, and photographs, to name just a few. If any two of these items are used in any correspondence, research, QA monitoring, or reporting, they must be de-identified. However, any or all of these items may be used within the normal operations of the office or institution, or as it is defined in the law within the TPO as defined in the HIPAA statutes. The definition of TPO will be explained on a later slide. The privacy requirements under HIPAA law can be summarized under three main categories as shown on this slide. The privacy standards category includes the Notice of Privacy Practices. This document delineates the uses and disclosures of health information under HIPAA law. The patient signs an acknowledgement of receipt of this document when becoming a patient of record. The Notice of Privacy Practices is posted in the first floor reception area of the clinic for review by patients and others. And additionally, the patient will receive a copy of this document when the acknowledgement is signed. Patients' rights are also covered in this notice, which would include a patient's rights to access, copy, and amend PHI. Administrative requirements under the law mandate policy development, designation of officers, posting of notices, and other compliance issues. Penalties may be assessed for violations of the HIPAA law. The knowing use of unique health identifiers or obtaining or disclosing individually identifiable health information is subject to fines and/or imprisonment of up to $250,000 and/or 10 years in jail. As you can see by these penalties, the risk to the school is significant. Please make every effort to be in compliance with all HIPAA statutes. Healthcare providers, dentists, or dental care institutions are given certain rights under the law as well. Two of the most important rights given to the providers are allowed to impose charges for the copying and distribution of patients' healthcare information, and providers can deny a patient's request to make a change in their record. A patient is allowed to make a separate addendum or amendment to the record, but not to change or alter the record itself unless the provider agrees to the change. How does this law then affect our school? Who must comply with this law? All healthcare providers, including all physicians, dentists, medical and dental schools, all healthcare plans, and all healthcare clearinghouses. Additionally, businesses that have access to PHI in a healthcare practice or through a healthcare plan must comply with all HIPAA laws. The major purposes of the HIPAA privacy regulation are seen on this slide. Number one, to protect and enhance the rights of consumers by providing access to their healthcare information. Number two, to improve the quality of healthcare by restoring trust in the healthcare system. And number three, to improve the efficiency and effectiveness of healthcare delivery by creating a national framework for health privacy protection. The minimum necessary standard applies to all aspects of the HIPAA law. That is, you must make all reasonable efforts not to use or disclose more than the amount of PHI necessary to accomplish the intended purpose of the diagnosis or treatment. Always remember that less is better. The HIPAA law mandates the designation of officers to enforce HIPAA policies and procedures within a practice or an institution. The following officers have been designated for the Arizona School of Dentistry and Oral Health. The compliance officer is Dr. Cederberg. The privacy and training officer is Dr. Cottom. The security officer is Elizabeth Russell, and the contact person is Colleen Culverhouse. Additionally, the HIPAA committee includes Dr. Jim Bell and Dr. Maury Reisbeck. Implementation of the HIPAA compliance program for ASDA began on March 28, 2005, with the publication of the Policies and Procedures document and the posting of the Notice of Privacy Practices. Acknowledgement of the receipt of the Notice of Privacy Practices began on March 28th. In the month of April, business associate contracts were finalized and signed. Initial HIPAA training was completed on April 11th, and data safeguards for protection of electronic PHI were enacted. Assessment of the HIPAA program is an ongoing process. Policies and procedures will be periodically reviewed and amended as needed. Training will be tracked and modified when recommended, and all complaints will be tracked through the Quality Assurance Program. PHI may be disclosed without specific patient authorization when used during the normal course of business, whether it is in private practice or in a medical dental school or an institution. The vernacular that the HIPAA law uses is TPO. T stands for treatment, which includes risk assessment, disease management, or referrals to other specialists. P stands for payment, which may include the determination of coverage, billing, insurance claims, or processing financial information. O represents healthcare operation, which may include quality assurance, preparation for accreditation, training, or any number of other uses of PHI, which may take place within the usual operations of a healthcare provider. All patients must sign the acknowledgement of receipt of the Notice of Privacy Practices once they've had a chance to review the document. Once signed, this document needs to be scanned and saved into the patient's record. The patient may refuse to sign the acknowledgement, but this does not preclude the patient from becoming a patient at the school. If a patient requests access to their PHI, a form is available for this request and is available either electronically or hard copy in the Office of Clinical Activities. This form is the Health Information Access Response or Delay. The school has 30 days by law to provide access to a patient's PHI, and an additional 30 days if PHI is kept off-site. Usual and customary record copying fees apply for providing copies of records, radiographs, photos, and the like. This fee is charged at the discretion of the institution or practice and may be waived in certain circumstances. If a patient would like to lodge a formal complaint pertaining to HIPAA, a complaint form is available in the Office of Clinical Activities. The patient must complete the Patient Information section in Section A, and an explanation for the resolution to the complaint is given in Section B. This form must be signed and dated by the patient, and a copy given to the patient if requested. This form will be kept on file in the Office of Clinical Activities. Upon completion of HIPAA training, faculty, staff, and students must sign a Review of Policies and Procedures document, which is an official record that formal HIPAA training has taken place, and is a verification that those who have completed the training have the authority to view and manage PHI for patients at the school. This form will be kept on file in the Office of Clinical Activities. A protocol has been developed which addresses how review of patient records for research purposes will proceed. The Internal Review Board, or IRB, will be the gatekeeper for prospective and retrospective research projects which utilize PHI. A statistician or other qualified expert will be responsible for de-identifying PHI so that this information is suitable for publication or when it is used for other educational purposes. Finally, let's close this training session with some common do's and don'ts when managing PHI in a clinical setting. Please close all computer screens when not in use. Patients or other unauthorized personnel may walk within viewing distance of your computer screen and may be able to read your patient's sensitive PHI. Never use PHI without appropriate cause. That is, never share PHI with others unless it is within the TPO of the practice of the institution or it involves the communication with a referring practitioner or specialist. Do not discuss PHI in openly public settings. That is, in hallways and elevators, in areas where people may be milling around or congregating. You never know who may overhear the conversation. It may even be a relative of the patient you're speaking of. Our clinical areas at the school are open bays, and sound carries very well in these open spaces. Please use a lowered voice when discussing your patient's health history and when reviewing their PHI. If you become aware of a patient complaint related to HIPAA compliance, please notify the HIPAA contact person as soon as you become aware of the problem. Please direct any questions that you may have to the school's HIPAA officers or anyone on the HIPAA committee. The HIPAA committee will respond to any changes in the HIPAA law either on a state or federal level and will modify our protocol, procedures, and policies as needed. Remember that the HIPAA law is a federal law, and noncompliance with HIPAA statutes could be significant for the school in terms of penalties and other problems that may occur. Thank you for your attention during this training session.